Hi, everyone. Welcome to today's episode. I'm glad you're here. Today, we are talking about the very important topic of how to get children's voices heard in custody cases. And parents ask this question, and lawyers ask this question sometimes. The entire system has been focusing more lately on children's voices and getting that into court, or at least getting it considered in cases. In Colorado, where I practice, we use the best interest standard, and that is used in most states across the country. It's used in a lot of countries internationally as well. It's by far the most predominant way that courts and family law attorneys and parents, therefore, need to analyze cases. In some states, we have ages where the children are given more weight, where their opinions are given more weight. So for example, it will say at age 14 or something around that age, a child's voice gets more weight than other factors. But in almost all jurisdictions, it is not the case that a child just gets to choose at a particular age. That's a very common misconception that I hear frequently, especially from children and a lot of times from their parents, where they'll say, well, I heard that when I'm 12, I get to pick. I heard when I'm 14, I get to pick. And parents think that's true a lot of the times also. So this is an important topic for you all to consider. And there are a lot of ways to get children's voices into court. Well, I want to start, though, by just saying that in Colorado and across the country, first of all, you need to think about, are you asking the question of getting a child's voice heard because you're trying to have an adversarial approach to this that is attempting to block a child's in a relationship with one parent? It's just a very important question to ask yourself, because that is usually the undertone in which I get those questions. The question comes to me sort of like this. I want to know how to get my kid's voice heard because my kid hates the other parent and really doesn't want to see the other parent at all. Or my child really just prefers to live with me and not with the other parent, and I want to make sure that that can happen. That is giving weight to the child's voice in a way that is not necessarily considering all the best interests. So I'm going to talk a little bit at first here about what those best interest factors are. And hopefully it'll frame not only for you how the courts look at it, but also how you might want to look at it. Because these factors, while they're not perfect, they have been heavily considered by advice of all sorts of people. Statutes come out of the legislature, but they're informed by psychologists, health professionals, family law attorneys, a lot of different historical knowledge about what is best for children, and they are written the way they are for a reason. So parents, instead of fighting against those factors, really might want to consider why those factors are that way and whether or not you are actually meeting those factors when you're saying, is my child's voice going to be heard, or how to get it heard? And make sure you listen through the entire episode, because as I go through, I will give a lot of actually active ideas as to how to get your children's voice in, even without a child advocate. In Colorado specifically, and again, for most states, but in Colorado, I'm going to cite to Colorado Revised Statute 1410-124, 1.5 is the subsection. We ask for what the allocation of parental responsibilities shall be. The court shall determine the allocation of parental responsibilities, including parenting time and decision-making, in accordance with the best interests of the child. And so what are those best interests? The best interest factors that are set out in subsection 1.5a, there's 9 of them. And these are required in Colorado to be considered when determining parenting time. And even if you do a case on your own and you're just going to court to get it adopted and you're not asking the court to make the decisions, you still have to say in your documents that this is in the children's best interests. And so you are essentially acknowledging that the best interests, which is these 9 things in Colorado, are being met in the plans that you're putting together. The first one is the parent's wishes. The second one is the child's wishes. If he or she is sufficiently mature to express reasoned and independent preferences as to the parenting time schedule. Okay, I'm going to get back into that because this is the key thing we're going to talk about today. And I will have another episode in the future on just best interests in general, but it's important to frame this conversation about children's voices with what these factors are. The third one is the relationship between the child and parents, siblings, and any other person who significantly affects the child's best interests. Fourth is the child's adjustment to home, school, and community. Fifth is the mental and physical health of everyone involved, although there's a caveat that disability alone cannot be a basis to deny or restrict parenting time. Sixth, the party's abilities to encourage the sharing of love, affection, and contact between the child and the other parent. Again, a caveat on that is that actions to protect a child from witnessing or suffering abuse shall not be considered for this factor. Seventh, whether the party's past involvement shows a system of values, time commitment, and mutual support. Eighth, how far apart the parties live. And ninth, the ability of each party to place the needs of the child ahead of his or her own needs. And so there's a lot of things that people come to attorneys with and say, oh, he was looking at pornography or she had an affair or things like that. Now, those things could affect the relationship with the child, but generally they don't. Okay. So you've got to recognize that there are a lot of things that affected the marriage that do not affect the best interest analysis. And so, for example, there's cases where somebody has a job that might be, I don't know, like I had a case once where the mom was working as a adult dancer, for example, and the dad didn't want that mom to have parenting time because of that. That doesn't work unless there's something else going on that actually affects the child. Like religious preferences wouldn't be something, or someone's salary wouldn't be something, or an educational level of a parent, or that a parent is in therapy. Those things are generally not things that would be considered. Also, like previous criminal conduct would not necessarily be something that matters. And although if we have something like alcohol abuse or drug abuse, that really could be something. And that is something. Same with domestic violence, that can be something. Specifically, too, you need to understand that Colorado does have a statute that says that domestic violence can be considered, a child's voice needs to have paramount consideration in the way that we look at the case, and the child's voice really does need to be heard in that kind of situation. So those are things that affect the best interest standards, and that is something that parents really need to think about as they are considering in their own case and their own family what they mean by getting a child's voice heard. The child's voice can come in through that report. So can the voice of all those other people who are interviewed by the CFI or the PRE, or whose documents were considered. All that hearsay comes flowing in. And so if you've got a case that's running off to court, it can be lots easier to get all those voices in through that expert. And that is the massive upside to a CFI or a PRE. Okay. Downsides, though, we'll just jump through these really quick again. Cost, especially for the PRE. The CFI is very cost effective, honestly, but again, I think limited compared to other options and not as effective. PRE is extremely expensive. Time, it takes many months to get any feedback at all. Usually 4 months. Okay. For a PRE, usually longer than that. PRE's waiting time to start is usually longer, and then it often takes at least 6 months to get these things done. So you might be looking at a year before you're even going to get feedback. Okay. Also, third downside is that the family's needs continually change, and the CFI and PRE can have a hard time keeping up with those changes. You're always trying to get your reports done, and the writing of these things takes a huge amount of time and effort to get it right. And the dynamics keep changing the longer it takes. So, it's very common to get something where they'll say, oh, we just had this new thing happen, and we need you to re-interview the children, or we need you to go consider this new incident that happened, or this new thing that happened at school, or this new need that just came up. And while those dynamics keep changing, it's very difficult and sometimes doesn't even happen that the CFI and PRE will consider those things. So very, very difficult with the nuances of families to keep up with that. Also, because these are experts, you kind of have limited access to that person outside of this seriously controlled structure that they create. So you won't have as much access. Also, there is usually and almost never ongoing contact with the kids. So that again is going to be very carefully structured and controlled and has a hard time keeping up with the ever changing needs of children. And frankly, even sometimes their ever changing opinions, right? Because it's very common that a teenager might get mad at one parent or the other and shift the perspective very rapidly.